Welcome to Immigration Quicktake. This is Ellie Rutledge with the American Immigration Lawyers Association. Thursday, a U.S. District Judge in Texas heard beginning arguments on a lawsuit filed by Texas and 20-some other states seeking to negate President Obama's executive actions on immigration. Here to discuss the hearing and lawsuit is Melissa Crow, American Immigration Council's Director of the Legal Action Center. Melissa, thanks for joining me. What does this lawsuit address?
So the lawsuit that's currently pending in a federal district court in Texas is a challenge to two of the initiatives that President Obama announced on November 20th. The expansion of the existing DACA program and the DAPA program, which will grant deferred action to parents of certain lawful permanent residents and U.S. citizens. The states, which include Texas and some 21 others, are alleging that President Obama has violated his authority under the Take Care Clause of the U.S. Constitution, which provides that the president must take care to faithfully execute the laws, and also that he's violated the Administrative Procedure Act. Essentially, the states are alleging that President Obama has exceeded the scope of his executive authority, and that's simply not true. What the president has done in the case of both of these initiatives is consistent with his authority under the Constitution and is consistent with what many other presidents before him have done over the years. We're confident that the courts will ultimately affirm this.
Thanks, Melissa. What was Thursday's hearing about?
So Thursday's hearing focused on a request by the plaintiff states for a preliminary injunction, which is a temporary block of the expanded DACA and DAPA initiatives while the case works its way through the courts. There actually was no decision yesterday. I think the hearing went for about 3 hours, and the judge said that he was going to rule as quickly as possible, but the government had actually requested an opportunity to submit one additional brief, which is a surreply, essentially a response to the reply that the plaintiff state submitted following the government's submission of its opposition to the preliminary injunction. The judge gave the government a deadline of January 30th to submit that brief, and so we expect to see a ruling sometime between January 30th and the date when the expanded DACA program is supposed to go into effect.
What will happen next with the lawsuit?
Well, there are a couple of different possibilities for what could happen. The best case scenario, of course, would be if the judge denied the preliminary injunction and dismissed the case. Although the hearing yesterday wasn't technically a request that the case be dismissed, there was a very similar case that was heard in the District Court for D.C. a couple of weeks ago that was in a similar posture, and the judge actually asked the government if they would mind if she treated their opposition to a preliminary injunction as a motion to dismiss the case. The government, of course, had no problem with that, and the judge dismissed the case very soon afterward. That case is now on appeal to the D.C. Circuit Court of Appeals, and the plaintiff in that case has requested that the appeal process be expedited. So best case scenario would be that the same thing happens here, and we presume that no matter what happens in this case, there will be an appeal to the Fifth Circuit, either by the plaintiff states or by the government. It's possible that if the judge issues a preliminary injunction in this case, it may apply only in the plaintiff states that are involved. This would create an implementation nightmare for the government, although I'm guessing that it would be preferable to blocking the case throughout the country, because there would be sort of a patchwork of rules that applied in different states. It's not clear whether the Texas judge has the authority or even thinks he has authority to issue an injunction that would go beyond the states that are directly involved in this lawsuit, but time will certainly tell. If the case goes up to the Fifth Circuit, and we think it will no matter what happens, initially it will be heard by a 3-judge panel. And we presume that if the result goes against the government's position, the government will very promptly request that that decision of the lower court be stayed. So the injunction would not go into effect until at least the decision of the Fifth Circuit Court of Appeals is issued. Once the Fifth Circuit rules, there could be a request for a reconsideration by the three-judge panel. There could also be a motion for rehearing by the full Fifth Circuit, which is called an en banc rehearing. And ultimately, this case could go up to the Supreme Court.
Thanks, Melissa, for joining me. For the rest of you, please stay tuned for more updates from the American Immigration Lawyers Association.